The Board of Zoning Appeals to order here this morning. And our first case is case number 6287. And Mr. Dixon, would you go ahead and introduce the file for us, please?
All right, case 6287, an application for a conditional use for a commercial kennel and 3 distance variances. The site is located at 1280 Woods Road, Westminster, Maryland, on property zone A, Agricultural District in Election District 7. By Andrew R. Jones, Code of Public Local Laws and Ordinances, Section 158.070E1I and 158.040. A site visit is tentatively scheduled for Wednesday, January 20th, 2021 at approximately 9:30 a.m. In the file of this matter, we have the following documents. Site minutes on page 3. Joe Vance sent a memo to various state and local agencies on December 22nd, 2020, asking for a response. There's a January 15th, 2021 letter from Linda D. Eisenberg, Secretary to the Planning Commission, to the board. After having reviewed the information contained in the attached analysis, the facts as presented in the application, the relevant portions of the plan, and in accordance with the provisions set forth in the land use article, this conditional use request, if granted, is not inconsistent with the policies, timing of the implementation of the plan, timing of development, timing of rezoning, development patterns, land uses, and densities or intensities. There's a January 12th, 2020 letter, or I guess should be 2021 memo from Hannah Weber, planning technician, to the board. The above referenced BZA case has been reviewed for consistency with the policies and recommendations contained in the 2014 Carroll County Master Plan as amended in 2019, the Carroll County Water and Sewer Master Plan, and other functional plans. The staff finding is that this request is not inconsistent with the 2014 Carroll County Master Plan as amended in 2019 and could possibly have an adverse effect on the current use of the property due to the size of the property and surrounding properties, proximity of neighboring properties, and the large variance reduction. There is a response to Joe Vance's request to various state and local agencies from Laura Mateus, Bureau Chief, Development Review. A site plan will be required in accordance with Chapter 155. There is a response to Joe Vance's request from Tom Harris, Permits and Inspections. A building permit is required for the kennel structure. The areas for viewing and interacting with the dog shall be ADA accessible. Hearing notice was posted December 28th, 2020 by Scott Robinson, zoning inspector. There is a response to Joe Vance's request to various state and local agencies from Matt Shipley, Carroll County Environmental Health Department. Comments: proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply and adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses on this property. There's a newspaper ad dated January 4th, 2021 for this case. There is a response to Joe Vance's request from Deborah Bowers, Program Manager, Ag Land Preservation Program. Not in agricultural land preservation per initials DB. There's a response to Joe Vance's request from Dawn Kenna, Humane Society, Animal Control Officer, Dispatch. Comments? No comments. There is a response to Joe Vance's request from Christopher Hahn, Bureau Chief, Resource Management. Comments? No comments. There is a response to Joe Vance's request to various state and local agencies from Jay Voigt, Zoning Administrator. Comments: variance requested are for setbacks from the 200-foot setback to property lines of the lot less than 3 acres. 200 feet from property line to 15 feet, 200 feet to 43 feet, 200 feet to 95 feet from front property line. Setback to rear property line complied with 200 feet requirement. Jovan sent a notice of public hearing to the applicant, adjoining property owners and interested parties, December 22nd, 2020. Then there's the application for the conditional use for commercial kennel and variances. There's a location drawing from, looks like Philip J. and Kimberly A. Vecchiani. I would ask that the file, there's an aerial photo with a blue rectangular figure of the property too. I would ask that the file be entered in evidence.
So moved.
So second. All those in favor, raise your hand and or say aye. Okay, the motion carries, and we will enter the file into evidence. Before we get started here this morning, let me go through the procedures that we use for a BZA hearing. Our procedures are that the applicant, that would be the Joneses, go ahead and present their case for their application. And after their testimony, then anyone from the public that may have questions about it can ask them questions of their testimony, and then board members will have the opportunity to do the same. After they're finished presenting their case, anyone from the public can go ahead and make their comments either for or against the request today. So that's the procedure we're going to use. So if you are going to testify in this case, or I would ask that you raise your right hand and take the oath. So the Joneses, I would assume that would be you and any other interested parties. So please raise your hand. Do you swear or affirm under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Very good.
Yes.
Okay, thank you.
I do.
I do.
With that, I see we have three people that have agreed to that have taken the oath here today. Okay, and please, before you begin speaking, please state your name, address, and occupation, and spell for the record your last name. So with that, Mr. Jones, would you go ahead and lay out what your request is here before the Board of Zoning Appeals?
Good morning, Andrew Jones. So 1280 Woods Road. I am a professional firefighter in Montgomery County, and then also the business owner of Eastwood English Labradors, LLC. And we have applied for the commercial kennel license. We have 2 dogs that we plan on breeding. And in order to breed them twice a year, we would need the commercial kennel license approval. We are not actually building a separate structure. We'll be operating out of our house that we're currently in, so there'll be no additional buildings based on the property. We just need the license for the breeding. All our dogs are up on their shots currently and licensed with the county. And we also have a electric fence installed for the dogs as well.
Okay, any other testimony, Mr. Jones?
No, just the main thing, like we said, that want to let everyone know that we will not actually be building a separate kennel on the property. So,
Okay, does, okay, we'll go ahead, we'll ask the questions later. Does anyone from the public have any questions of Mr. Jones' testimony? And again, just ask him questions, his testimony, you'll have the opportunity to provide your own testimony later.
Mr. Bale,
Mr. Varsox, yes.
good morning. Good morning, the rest of the board. I'm here on behalf of Michelle Tracy, who is an adjoining property owner.
Okay,
And I have some questions for the Joneses.
okay, you can proceed, Mr. Varsox.
Thank you very much. Good morning, Mr. and Mrs. Jones.
good morning.
What is your residence address?
1280 Woods Road, Westminster,
All right, so-
Maryland.
You reside on the property now?
Yes,
All right. And the Coyles are the owners, correct?
yes, sir.
What is your relationship to the Coyles?
They are
My
Alina's grandparents.
Okay. And are you renting space from the Coyles?
Yes, currently renting.
All right. And where do you live on the premises, if I may ask?
House and there's an apartment and also attached above the garage. My grandparents currently reside in the apartment. We live in the main house.
Okay, so they are residing in the apartment over the garage.
Yes, they reside at 1280 Woods Road as well.
Okay, so has that garage second story been converted to an apartment?
It was an apartment when they purchased the house in 2012.
All right. Do you know if there's been a building permit obtained for that apartment unit?
I'm sure that there was, the apartment was built before we ever purchased, before my grandparents ever even purchased the home.
Okay,
It was put on by the previous owners.
the Vecchionis.
I'm sorry?
The Vecchionis
I'm not sure
were
who.
the previous owner? Okay.
Joan is saying yes. I don't know.
All right, so the grandparents are in the apartment.
Correct.
How long have you been residing there?
Since November of 2020.
So roughly 4 months.
Correct.
And the application indicates your status is a contract purchaser.
I'm sorry, I can't hear you.
In your application that you filed with the Board of Zoning Appeals, it states that your relationship to the property is a contract purchaser.
Yes, the rent to own situation.
Pardon me?
Yes, we're in a rent.
I'm sorry, but I'm not picking up the audio.
We are in a rent to own situation.
Okay. And is there a written document that establishes that rent-to-own situation?
Not currently.
All right, so it's kind of a loose arrangement, so to speak.
At this moment, yes.
And when did you enter this rent-to-own arrangement? At the time
It was
you moved
original.
in?
I'm sorry?
Was it at the time you moved in, you entered this rent-to-own arrangement?
No, it was discussed in September of 2020. We sold our house that, Andrew and I sold our house that we owned in Tawnytown to move out here with my grandparents. And in September, it was discussed and put into place.
All right, so there's no settlement date and no contract with contingencies on zoning or nothing like that at all?
No.
Okay, I'm just trying to make
No, sorry, I was just confused
sure I
by the
understand.
question.
All right.
Okay.
And do you have dogs now?
Yes, we currently own
Okay. and
English
do you
Labradors
have
that will
them-
be breeding.
Pardon me?
We have 2 English Labradors we will be breeding.
English Labradors.
Yes.
so
Registered
those-
Yankees.
Okay, those are the breeding stock you're intending to use?
Yes, Labradors.
Okay. And they're residing on the premises with you now?
Yes.
What are their ages?
We have one registered under the name of Jassy, who is April, and we have a yellow female named Nala, who is 8 months.
8 months, and how old was the first one you mentioned?
20 months.
20 months, okay. So are you breeding them now?
Jassy has been bred once, yes.
And that's, which one is that?
Jassy, the one that's imaged too.
All right, the 20-month or 8-month old?
The 20 month.
All right. And where did you do that breeding? Was that before you
Out
lived?
of our home.
Okay, at
Right.
1280?
She became pregnant before we started residing at 1280 Woods Road, but her puppies were born at 1280 Woods Road.
All right, so you've already had one litter on site.
Correct.
Okay. Where will the dogs be kept on the property?
They're kept inside. We have a finished basement that has a room separate that we do all of the birthing, or that we intend to do all of the birthing in, and you know, there's heat, water, electric, all of the above in that area. That is the main area where the dogs are kept. And then we have a fenced enclosure in the backyard where they are allowed to go outside.
All right. And what is your background with these dogs or other breeds?
What is our background with these dogs? I'll try to answer that to the best of my ability. I'm not really sure what it is that you're asking. I've been being mentored for the last 2 years by a breeder who has been breeding Labradors for 33 years. I purchased both of my females who will be a part of my breeding program from that Shady Side Acres, which is the breeder who's been doing it for 33 years. I've owned them both since they were 8 weeks old.
All right, both of your females that you mentioned, are those the 2 dogs you have?
Right.
All right. So you're not going to be, you're going to be breeding them off-site?
No, I have to take the dog off site to be bred, you know, with the stud service, but then she comes back on and resides here at 1280 Woods Road and gives birth to her puppies, and the puppies are raised inside here at this house.
But
Or
the
that's what we
stud
plan.
operation is not part of what you're contemplating at 1280.
No, we have 2 females that we intend to breed, Jassy and Nala, the one that's 20 months old and the one that's 8 months old. And those are the only 2 dogs that we even plan to breed. But per the county and the state, I believe it's if you're going to have more than 1 registered litter a year, you have to apply for the commercial kennel license. But we're not actually applying. It got kind of tricky because we're not actually applying to build a separate structure or to own and operate an outdoor kennel. You know, the 2 dogs that we have that will be breeding will produce obviously more than 1 litter a year. It'll produce 2 litters a year, but they live inside with us. It's just like
Well-
having your average family dog, except for they're having a litter of puppies.
Okay, right. Your application today is not necessarily dependent on a structure. It involves
Right.
the use of the property.
Right, to
How-
legally be able to breed.
Okay. how long have you been doing this, the breeding of dogs?
The litter that Jesse just had was the first litter that we've had, so less than a year.
All right, so your audio just broke up for me. So that one litter you mentioned was your first time?
Was our first litter, yes. So we've been doing
Okay.
it less than a year.
How many litters per year do you anticipate producing at the site?
2.
2, 1 from each of the dogs.
Correct.
Now, you mentioned that these dogs are being kept indoors. They're not outside.
Right. They get let out to use the bathroom and go out and play and things like that with us, but they reside indoors. They sleep indoors. They eat indoors. They live indoors.
Okay. Where were you living previously?
32 O'Brien Avenue, Tawnytown, Maryland, 21787.
All right. And what made you decide to move out of O'Brien Avenue and into your grandparents?
My grandparents are planning to, well, my grandfather's already retired. My grandmother's plans to retire soon, and pretty big house and has an in-law suite. So my children and I and Andrew are moving into the bigger house, and they're moving into the apartment.
All right. How many children do you have?
2, an 8-year-old and a 5-year-old.
Okay. All right. Do the Coils have dogs?
They have a Yorkie, yes.
One dog?
2 little Yorkies, but they're indoor dogs.
They're what?
Indoor. They're kept indoor at all times
Where are they kept?
in the apartment with my grandparents.
And do the Coils breed those dogs?
No, they're spayed and neutered. Like 15 and 16-year-olds
So are your dogs registered anywhere?
with the AKC.
Okay, so the house was there when you arrived, obviously, and you want them inside.
Correct.
You're applying for variances as well.
Because I have to. It was
I agree.
required that we, yeah, it was required that we do so.
Okay. The legal standard for variances involves 2 things, that there's something unique about the property, and according to the board's authority to grant variances, that there be some demonstrated unwarranted hardship. I believe, yeah, unwarranted hardship and injustice. So what is the unique aspect of the property?
My understanding of why I needed to apply for the variances when applying for the commercial kennel license was because my property lines were under 200 feet from the neighboring property lines. But I was
Your
also
grandparents.
told, I'm sorry?
Your grandparents' property lines.
Correct. The property lines that we're applying for the variances on are my grandparents' property lines, but Andrew and I are the ones applying for the commercial kennel license. I was told that I had to apply for the variances, but that it really isn't this. I don't really know how to explain it. It was like the technicality, but it would have been for building a structure out in the yard. But I'm not really applying for a variance because I have no new structure being built. The dogs are living and residing in a home that's already on the property.
Well, again, this proceeding involves a use, not necessarily a structure. And if the structure you're using is already in existence, that's the basis for the variance. So that's the unique features. The boundary line is where it is relative to the house. And what are you asserting as the unwarranted hardship?
I believe you're asking what the hardship would be, the distance. I'm not really sure other than that.
Okay. Have you considered doing this operation anywhere else?
No, because our dogs are a part of our family.
But you know you're applying for a commercial kennel.
Yes, for legality purposes. To prove that I'm responsibly breeding so that I can get a license with the Carroll County Humane Society. And so that they can come in and do twice a year, they will do an annual inspection of the area where my dogs are kept and prove that I'm doing things appropriately and responsibly for the welfare of the dogs.
Okay. Now, how will your customers find you?
The internet, word of mouth, referral from other breeders in the local area.
Okay, but this is still a new experience for you, so you're kind of learning by doing.
Every puppy in the litter that I just had was spoken for before they were born. They're
Okay.
all already purchased.
Well, and that's sounds like you've had some success with your first litter. I'm just
And with
curious.
the referral program that I'm a part of, I'll have success with every litter that's bred in this house.
Okay. All right. Are you otherwise employed, both of you?
Andrew is a professional fireman in Montgomery County. I'm not.
You're not employed. And okay, you mentioned you have 2 children. They're living with you?
Correct.
Okay. I have no further questions at this point for the Joneses. Thank you.
Thanks.
Thank you.
Does anyone else from the public have any questions of the judge's testimony?
I do.
Yes.
Okay, identify yourself, please.
This is Joyce King. My property is connected, we abut in the back. If this is approved, there will be a commercial kennel on record in back of my property. And I called a realtor to check this out. And this is a potential, this could affect the marketability and the value of my home. So I'm a little concerned about that.
Okay, Ms. King, do you have any questions of the Joneses' testimony?
No, I'm just stating the fact that why this,
Okay.
I'm on here and why this affects me.
Okay, there will be an opportunity for you to give your own testimony, but a little bit later. We're trying to wrap up here with the Jones.
Okay.
That's okay. This is your first BZA hearing, so you get a pass card. Okay. Does anyone else from the public have any questions of the Joneses' testimony?
I have one thing I'd like to follow up on.
Okay, Power Sox, go ahead.
I'm gonna try to share my screen if I may. Thank you. All right. Can you see this screen?
Yes.
All right. And for the board's edification, this is page 10 of a package that is the use and occupancy permit and building permit application for 1280 Woods Road. And the page I'm showing you is the January 20th amendment to the building permit for the 3-car garage. You can see the description of work as a 3-car garage with an unfinished second floor, and to extend the existing family room and bathroom in the house. I'm going to roll this to the following page, which was the original application from 10 days earlier, January 10th, that has been abandoned, seeking a 3-car garage with an apartment on top. And if I may, if you'll hold on with me, I'm going to go to the first page, which is the permit itself. And you can see that what is described on this permit is an attached garage and breezeway with the second floor unfinished. Now, I obtained this yesterday from building permits as the current state of affairs in terms of permits for this structure. So my question, I guess, to the Joneses is, are you certain that your living arrangement is appropriate? I mean, do you know anything about this, the Coyles?
Alina.
All right, I'd like to introduce this on behalf of Ms. Tracy. I have earlier today forwarded this to Ms. Vance and copied to Mr. Dixon, by the way.
We can't see.
We will accept that into evidence, Mr. Bowersox.
Thank you, Mr. Dale.
Like locked.
Yeah. Okay.
We weren't able to talk.
Okay, does anyone else have any questions of the Joneses' testimony? Okay, board members.
I'm sorry, sir.
Wait a minute. Ms. Jones, did you have a comment?
I have a question.
Can you hear me?
Miss Jones, we can't hear you. You need to be closer to the mic, I think.
Can you hear me now?
That's better.
I think someone else has theirs on. There's a lot of static in the background that's not coming from me. I can't hear any of you.
That was hard to hear you all.
Can you guys hear me now?
Yes.
All right, there we go. I guess I was just wondering what Mr. Bowersox, what the relevance to my grandparents' apartment was. But what I want to know what you're questioning. With the unfinished floor above the garage, I'm just wondering the relevance to my 2 dogs who will be having a litter once a year per dog. I'm wondering what that has to do with my grandparents' unfinished apartment that you're referencing.
I asked you if you were aware that you've described
I'm
2
wondering what-
residents at this location.
Am I
It's
aware of what?
been approved for 2 residences as you described them, one of which is a
It's-
rent to own. That's all.
Well, like stated earlier, there's not really a contract. We live here. We help pay bills here. My grandparents live here. The apartment has an opening that comes directly into our side. It's not 2 separate entities.
So you're basically their guest.
Sorry,
You're
Can't hear you.
basically their guest.
I guess. I guess you could consider it that. I don't really understand what you're saying. I'm sorry.
Okay.
Okay, board members, questions of the Joneses?
You hear me okay?
Okay, Krista,
Yes.
go ahead. Can you identify yourself,
Okay.
please?
Yes, absolutely. My name is Crystal Jones, and I live at 1327 Laurel Lane, which is in the same neighborhood. I just have a general question. If this permit is approved, I understand that the intention right now is not to build a full kennel. It is only to breed the dogs in the home, and I'm perfectly fine with that. I'm just curious if a decision is made later down the line to turn it into a full kennel and build an additional structure and have more than just the dogs that have been mentioned today on site, will additional meetings need to take place for that?
But I'll partially answer that for you, Ms. Jones. Or the question is about the number of dogs and the future number of dogs. The Board of Zoning Appeals can put restrictions as to the number of dogs on the property, and we can also put restrictions as to where they are housed. And for example, the way they're presently being housed. So those things are left up to the Board of Zoning Appeals with a condition, as conditions of the approval if it gets approved. Does that answer your question?
I believe so. Just to make sure I'm understanding correctly, you're saying that if this does get approved, it'll be specified in the approval, the amount of dogs and where they will be housed in this approval. And should that need to change later down the line, additional permits and licenses will need to be obtained. Is that correct?
Yes, at least it would have to go before the Board of Zoning Appeals if they were found in violation of the conditions that this board may or may not want to put on this approval. Okay, so
Okay, thank you very much.
to do that, and your testimony is that the number of dogs and the way they're presently being housed is okay with you.
Yes, that's correct.
Mr. Vale?
Lisa, do you want to take over temporarily?
I can do that. Do we have any other questions from anybody that has called in?
Apparently, Ms. Cosmo.
Pardon me?
I didn't have a question concerning any of the information that's been presented. I just wanted to be sure that my comments were recorded. So whenever that time is made available.
Yes, we will come back to you and you will have the opportunity to provide comments.
Thank you.
Thank you. Board members, anybody have any questions?
Yes, I do. Mr. and Mrs. Jones, you have 2 breeding females. Are there any intentions of acquiring more in the future?
But our long-term goal isn't to stay residing at 1280 Woods Road. To kind of further go on what Crystal was saying, if we do eventually decide we want to upscale and, actually need a kennel outside or, have more than 3 dogs breeding at this residence, we have full intentions of moving and finding a larger property.
How many puppies are usually in a litter?
Literally, it can be anything from like 1 to 10. The current litter is 7, but they don't ever come outside. They reside in the house until they leave at 8 weeks old.
And how long would you keep them before selling them?
8 weeks from the time that they're born.
Okay.
So, for example,
Mr. Dixon, a legal question for you. Does a situation that is not consistent with the building permit in any way affect zoning approval in a case like this?
Well, I think we should hear from Mr. Bowersox first. He's the one that put the issue on the table. So let's hear what he has to say.
We did.
Well, I think you're dealing with the use of the commercial kennel. You're not dealing with the living arrangements who must have bedrooms and a kitchen. That's not what the Board of Zoning Appeals, that's not the issue you're addressing.
So that's a separate issue that we don't have authority over, right?
That's correct. That is the code, the building code official.
I have a question of Mrs. Jones. I didn't hear your response. The audio, maybe on my end, is breaking up, but how many dogs did you say ultimately you wanted to have on site breeding?
1 more than I currently have. I currently have 2, and I would intend
3.
to have at most 3.
Thank you.
You're welcome.
Can't hear you, Melvin.
Can you hear me now? Okay, I'm not sure what's going on. The question I have for the Joneses, presently you have 2 dogs and your grandparents have 2 dogs. So if your grandparents only had 1 dog, you wouldn't need the kennel license. Am I correct in assuming that?
Yes. But both my grandparents' dogs are, I believe the one is 14, the one is 16. They're little Yorkshire Terrier dogs. They live inside. They're trained to use the bathroom in sort of like a cat. They use the bathroom inside. They literally don't go outside. They're spayed, they're neutered. They're not a nuisance to anyone.
Okay, so you wouldn't have any issues with limiting the number of dogs and the present housing situation that you have with your dogs if the board was, if that was a condition of approval?
I mean, obviously that would, my answer to that would depend on what you guys were going to number me. Are you going to number me at 3? I mean, because if so, I have, there's 4 dogs already living here. So, I mean, I think that from what I understand, there's different levels of kennel licenses with, I don't know about with you guys, but with the Humane Society, there's different levels to that. there's one level that you can't have more than 10 dogs residing on your property. That's the smallest level of kennel license you can get from the Carroll County Humane Society. So something like that, yes, I'd be fine with. I don't have any intentions of having 10 dogs. Like I said, I've been on having 3, but my grandparents have 2. So
Okay. Any other board members have any questions? Okay, at this point in our proceedings, this is time for anyone from the public to go ahead and give their testimony. So does anyone from the public have any testimony to give? Go, the Redmonds, I see you have your hand up. Are you? I'm sorry, you're saying.
Okay, can I speak now? Can you hear me? Can you understand me?
Yes, we can hear you, yes.
Okay, thank you. I'm Joan Redmond. I live at 1272 Woods Road, right next door to the Jones and the Coyles. And before I go any further, I want to say that the Joneses and the Coyles are wonderful neighbors. They're good people, they're responsible, and they're a good family, and they're friends of mine, and I'm glad that they're here. They're trying to do the right thing the right way, which sometimes can be difficult. With that said, the hardship that approval of this waiver could be to the community, the road traffic. We have a private road that we have to maintain. We have to pay to repair it. We have to clear it with snow and everything ourselves. So it's not a county road. So my concern would be the increase in traffic, which would be pretty minimal. I understand that, but it still is an increase in the roads in bad shape. Another concern I have would be that this sets a precedent, as far as I know, in the neighborhood. It sets a precedent for commercial property in the neighborhood. And we all moved up here, and the Coyles and the Joneses did too. We moved up here because of the nature of the community being family-oriented, quiet, safe. And it's not a public road. There's only one way in and one way out. So this sets a precedent for possibly other commercial variances, which could be a hardship on the community. And it would change this particular variance would not change the nature of the community, but because a precedent is set, it could change the nature of the community in the future if other variances are approved for other commercial reasons that would maybe involve more traffic and more difficulty with the road. And my final concern would be, as someone else, Mrs. King mentioned, and I hadn't thought of this, to have on the books a commercial kennel right next door could make it more difficult to initially sell our house when the time comes to sell it. With that said, I understand there will be no structures. I've seen these dogs. I've barked at these dogs. These are good dogs. These are good people. They're very good, responsible people. But I just wanted to express the concerns that I have and possibly others in the neighborhood would have. And I would ask that if this variance is approved, that the restrictions be put in the variance to approve what the Joneses and what the Joneses are requesting. Approve what they're requesting and not open the door for future requests from anyone. In other words, just to preserve the community, just to protect the road. With that said, these are good people. Thank you.
Okay, does anyone have any questions of Ms. Redmond's testimony? Okay, does anyone else have any testimony?
Ms. Tracy would like to provide some comments to the board. Ms. Tracy?
Okay.
Yes.
Ms. Tracy, please, your name, address, and spell for the record your last name, please.
Okay, my name is Michelle Tracy, last name Tracey, and I reside at 1288 Woods Road, which is directly to the side of the Joneses and Coils. Technically they're in behind my house, so I'm the other variance that they're looking to have this commercial kennel variance. And here's the thing, I'm going to talk about the elephant in the room. I think everybody does not like the term commercial kennel, and I can appreciate what you guys are doing. You're great people, you're nice, but you have to understand that people want to protect their properties and their communities. And I actually work in the mortgage industry. I'm a mortgage professional by trade, and I can tell you that having it on the books that there's a commercial dog kennel right behind your house isn't something that anybody wants to have, especially if you're going to sell your home. My concern is property value. You have to understand that, being a homeowner. And, property value decline and future marketability. Jones and Sally Smith are going to come over here and say, I want to sell my house. And they hear that there's a commercial dog kennel license granted right behind me. What does that do for me to potentially, if I need to sell my home? I agree with Redmond's about the road. I don't know how much traffic, and everyone is concerned about this opening the door to future issues. This is a rural community. I've lived here 41 years. My parents built this home in 1980. And, people want to keep it country and community. And I understand that you want to keep the use inside your home, and that's perfectly well and good. But we all know that later down the road, nobody starts a business to keep it small. And, my concern is potential future growth of this, and the fact that it's on the books as a commercial kennel. Basically, my well is right by this property line. I'm not too tickled about that, having a variance right by my well. I'm 20 feet right away from that line. So, there's multiple things in the back of my mind that I'm concerned about.
Ms. Tracy, the line you refer to,
yes,
this is the variance of 157 feet from 200 feet to 43 feet from your property line, correct?
Correct.
And you've heard Ms. Jones say, well, maybe in the future we'll have to build something else.
Correct. I'm concerned about that.
Do you have a prior neighbor that tried to build something
I do.
near your property? Can you elaborate on that for the board?
Yes, years prior, the Vecchionis actually wanted to have a variance against the property because they wanted to build a structure in the front of where the home is now, and they wanted to variance over close to the line, which was right by my well. And it was number one, it was declined because of that, but number two, there was no hardship. There was no reasoning. He just basically wanted to build another large structure that was, a variance was granted on the property, and it was declined at that time.
It was for its convenience?
It was for convenience only. So, I'm in round 2 with variances here.
Okay, Ms. Jones, would you like to ask questions of Ms. Tracy's testimony?
Yeah, so her and Mr. Bowersox just said that they both heard me say that down the line, I plan to build another structure. That is not what I said. I said that I specifically do not plan to build another structure while I'm residing at 1280 Wood Road. Andrew Jones and I are currently looking for property to build a house on so that we can upscale our business someplace else. We're completely aware that you guys like living out here in the rural community, and we love the community, and we love the people out here. And my grandparents and I specifically love the peace and quiet and all of that. The traffic and things, I guess I do understand the concern there to a degree, but no different than when you have a birthday party once or twice a year and you have 15 cars driving back to your house. That's all the more that would be going on here at my house to have somebody come, say I have 7 puppies. All 7 families are going to drive to my house that year and pick up their puppies when they're 8 weeks old. That being said, this house is the second property on this lane. So we're the second people from the Pinch Valley Road, which is the next, I guess, county road from Wood Road, which is a private road. my grandparents and I are always quick to go out and help shovel and help maintain and do anything we need to do. And we would continue to do that, anything necessary to maintain the road. I don't really know what else to say other than that. I believe you guys said as the board, you guys are able to put in certain restrictions in place on how many dogs I can have, whether or not I'm actually allowed to build a structure or not. And I would be perfectly fine with you guys saying that I'm not allowed to build a structure. Because I don't need to build a structure and I have no plans in building a structure outside of this home, for one. Like I said, I know you guys have no control over this because it's a private road, but everyone in this community knows that my grandparents and I are more than willing to do anything to help out the community. And if that means going out and doing some kind of work on our part of the lane where people would drive on the first 200 feet of it, then we would be more than willing to help do that. That being said, I do also understand, I guess, the real estate aspect of things. I believe when we would move here, that it would no longer state that there's a commercial kennel behind your house or to the side of your house. And a 2-year goal would be for us not to be living here and have our business operating on another property, because you are right, we don't plan on keeping our business small, intention of eventually growing, but we don't intend on growing this property. We intend on staying exactly the way we are. And none of our neighbors have ever even seen our puppies. They don't even know our puppies are here. As far as they're concerned, we only have the dogs that they see in the backyard, the adult dogs. So the puppies being born and raised on the property indoors is really of no effect to anyone else. And I guess I don't really know this or know how it works, but even if you guys were to allow or permit us the commercial kennel license, how would that become how would everyone else find out about that? I guess is my question for you all. Because if we don't have some big, large sign in the yard saying, oh, commercial kennel out back, when anybody would drive by this house, the yard's meticulous, the house is meticulous, everything's taken care of so well. Unless you were to come in my basement, you would never know that there was even a puppy here, or a dog for that matter, because our dogs are not allowed to roam the whole property. We have a 30-foot, probably by 60-foot electric fence in the backyard. We don't even have room for the full back property. I understand that there's a 43-foot variance between me and Michelle Tracy's property, or my grandparents and Michelle Tracy's property, from that side of our house. Well, our dogs are kept in the part of the yard, half of the yard on the opposite side from that. So they're probably another 50 feet easily from where Michelle Tracy's well is. So I'm not quite understanding the concern there. I do understand that everybody wants to keep going to look into upgrading and maybe having another dog. We won't be here at this property, and we intend to fully respect all of your guys' wishes. And I don't know. I don't really know what else to say.
Okay, anyone else from the public have any comments?
This is Jean DeCosmo. I'd like to make some comments.
Okay, go ahead, and please state
Are
your
you
name.
able to hear me?
Yes, we can hear you. Please state your
Okay,
name,
sure.
address, spell for the record your last name, please.
Sure. So good morning, everyone. Jean DeCosmo, DeCosmo. My husband and I reside at 1316 Laurel Lane. We moved here approximately 25 years ago to raise our girls. I am a nurse of 40 plus years, still working full time, but also a realtor in a referral status at this point. Again, we sought this property because we wanted a safe, quiet, and private neighborhood. We moved from Baltimore City to raise our kids. I am very concerned about a commercial zoning in a residential neighborhood for all the comments that folks have made prior to me. This is not a personal thing at all. It's not about the Joneses. It's about the fact that we all have a stake here. I'm also concerned about the single lane. And while everyone says that they are willing to contribute, I will say that there's been inconsistency in terms of people joining and clearing the roads. It's difficult, especially in inclement weather. And I don't necessarily equate a commercial marketed business the same as having a family birthday party. Again, I moved here for privacy, and I feel that the neighbors are very much tuned into that, and that is one of the strong reasons that they've moved here. I feel that if I wanted to sell my home, I would be obligated to let people know that there was a commercial allowance within the neighborhood. And so it might be a disincentive for people who want to bring their children back here, not knowing what the potential could be. So for those reasons, I just disagree and am not in favor of this request. And again, it's absolutely nothing personal about the Joneses or the Coyles. It is just as a homeowner here, those are my feelings.
Okay, does anyone have any questions of Mr. Cosmo's testimony? Board members, any questions?
Yes, I'd like to clarify one thing. In addition to the distance variances, is a lot size variance needed? So this would be a question for either the Joneses or Jay Voigt.
Hey, you want to go ahead and answer that?
Okay, they would need minimum 3 acres for the property for any type of conditional use. So if they're less than 3 acres, they would need an acreage variance.
In the file, there's a reference to a lot size variance is needed. Yeah, it says 3 acres required, and the existing acreage is 1.65 acres. Is that correct?
Are you asking me, Mr. Wertz?
Whoever can answer the question.
Yes, Mr. Voigt, go ahead.
Yes, as I understand it, the property is less than 3 acres.
No further questions.
Okay, board members, any questions? Okay, seeing no further testimony, testimony and evidence is now closed and summations are in order. The Joneses, would you like to make any summation comments?
Can't hear you.
I saw your lips moving, Mr. Jones, but I didn't hear any words. So do you have any
We can't hear what you're asking. Do we have any what?
summation comments?
Any comments? The only thing that I could say again is that we're not building a structure. We would be as respectful as we know how to be with breeding the dogs, and like I said, we don't have any intentions of growing larger, and we don't have any intentions of really staying here for that matter. Just a stepping stone.
Okay, thank you. Mr. Batterstock, do you have any summation comments?
I do, and I'll be brief. We have here a request for a conditional use and variances. There's 3 variances shown for lot lines, the actually minimum distance requirements for this use. And there's also, as Mr. Wertz noticed and remarked about, there is a lot size variance request. So let's take the conditional use first. The Schultz versus Fritz standard is what you have here. We have a commercial kennel that has been applied for. If I could share my screen for a moment. Can you see that now? This is the zoning ordinance definition of the two kinds of kennel. Is that what's on your screen? On my screen, I should say.
Yes, we can see that.
All right. With a commercial kennel, if you're breeding more than 2 litters per year, you need a commercial kennel license. That's the one thing. The commercial kennel is referred to, if I may, the commercial kennel is a conditional use in the ag zone. Now, how are the adverse impacts here different at this location than they would be ordinarily on an ag zone site? It for one, doesn't fit neatly or easily onto the property. You've got you have 43 feet. You've got, I think, less than 20 feet on one side, and you've got a need for the various variances in the lot size as well. Excuse me. It's taking place. If you look at the application, the Joneses have indicated that they are contract purchasers. They've indicated that they have the same address as the owners. We've heard today that they have what they're calling a rent to own arrangement. It's not in writing, it's not formal, and that they are basically the guests of the property owners and don't have any real articulable right to be on the property. Now, if you take it a step further and you look through the information that we provided to you, this is all taking place on a property being used for 2 residences, a small agricultural lot, when it's only been approved for 1 residence and a 3-car garage with an unfinished 2nd floor. There were some problems many years ago, I will suggest, when the Vecchionis attempted to turn the garage into an in-law apartment. Permits was made aware of it. That's why they amended the building permit application that I showed you earlier today. And it seems to be what's been permitted is a residence and a garage, not an in-law apartment. So there's a bunch of questions going on in this neighborhood. You've heard the neighbors describe Woods Road. You've heard them describe the kind of close little community. You've heard the concerns over property values. This is not the right site for this use. When you add all of that together, yes, they are talking about 2 dogs, keeping them inside, 2 litters per year. That's all well and good, but what they've applied for is a commercial kennel. So we would ask that the conditional use be denied for that reason. As far as the variances are concerned as a whole, there's been no testimony or basis in a record at all to establish any unique circumstances of this property justify a variance. None. There's also no facts that have been introduced other than the convenience to the Jones of getting a variance so they can do this while they're staying with Ms. Jones' grandparents for an undue hardship. So they don't qualify for the variance either. We would ask the application as a whole be denied. Now, in the event the board is contemplating some kind of an approval of this, we would ask that any approval of this use, and this is not a concession, this is just an alternative argument, it has got to be restricted to no more than 4 dogs, 2 of which are involved in the breeding operation, no external structures. The dogs are kept inside, and that it lasts only for as long as Mr. Jones and Ms. Jones are on the site. They've already indicated it's their intention to move, and when they go, they're taking the dogs with them. She described it as a transition area. I commend Ms. Jones. I think she was being very forthright. But under the circumstance, with all of the other problems that this property now has, I believe you should make any approval you might be contemplating subject to conditions that would address those factors. Thank you.
Okay, the hearing and records of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. Board members, who wants to go first? Dr. Dunkelberger.
I guess I will. This is an interesting case. There are variances being applied for, and the hardship with the variance is you simply can't move the house to meet those distance requirements. We've heard from the Joneses that there will be 2 breeding dogs with 1 litter a year, 1 litter each a year. And we heard Mr. Dixon's legal opinion that whether or not the garage meets the occupancy permit does not really bear on what we have to decide here. I would be inclined to vote for it with a limit of 2 dogs, no structure, to be kept inside, and 2 litters a year.
Okay, Mr. Wertz.
Yeah, I have concerns about the application. The requested variances are major in nature, and the lot size variance wasn't reflected in the agenda. So there's 4 major variances being requested. I mean, personally, I don't see anything unique about this lot that would justify the variances. The lot is similar in size and shape to many other lots in the neighborhood, and I don't see any undue hardship. There's already a reasonable use of the property. So I'm inclined to not be in favor of the request.
Okay, Mr. Simmons.
Could you hear me, Melvin?
I can hear you now, Mr. Simmons. Go ahead.
I want to hear Lisa's opinion on this, if I might.
Of course.
Okay, Ms. Eckert.
I concur with Dr. Dunkelberger. However, I am also inclined, in addition to the conditions that he set, to stipulate that this use can only exist as long as the Joneses are in occupancy at this residence. And once they move, it would cease. So, you know, I understand that the neighbors have concern, and the word commercial kennel has been thrown around since the beginning of the hearing. I think Mr. Bowersox pegged it, though. This is not a commercial kennel. We're effectively talking about 2 what appear to be responsible potential, or, you know, want to be breeders, or I guess effectively breeders, since you've had, you know, bred your first litter, attempting to do the right thing so they can qualify as responsible breeders. And, you know, I feel like they're being punished, or there's the potential for them to be punished and not be able to have this use on their property because it doesn't fit neatly into the box. I don't believe that they're intending to build other structures. I don't believe that they're, you know, planning to expand this operation. So again, I'm inclined to agree with Dr. Dunkelberger, but limit this to for their use only.
What?
I'm sorry,
Limit
Mr.
what?
Once the Joneses are no longer in residence, then this use goes away. I do not think that we should be, you know, granting approval for a commercial kennel on this site, but I do think that we can grant what they are asking for specifically.
I agree with you, Lisa. I have some problems, as I do with other cases that involve future maybe what ifs. I'm hard pressed to think of another property that would be more suited than this one for this minimal use. I think the Joneses are, you know, from what I can hear, and it's basically, I'm at a distance, I can't even see the people, and with the intermittent interruption to the sound that I have, similar to Mr. Bale's problem, I hear them, and I believe them, and I intend to vote according to the conditions imposed or suggested by Dr. Dunkelberger. I'll vote in favor with your additional condition, Lisa.
I want to disagree on the conditions I suggested. I would suggest 2 breeding dogs. We heard testimony that the grandparents' dogs are old. If one of them should pass away, does that mean they could then have 3 breeding dogs? So I'd like to change.
We're talking about 2 breeding dogs. Isn't that accurate?
Yes, but there are 2 other dogs, and if we do a kennel for 4 dogs and limit it to 4 dogs, 2 breeders and 2 grandparents' dogs, one of the grandparents' dogs passes away, does that mean then we can have another breeding dog?
I think 2 breeding dogs is a condition.
I would agree with that.
Okay, I'm going to make my brief comments here. They've been there for 3 months. There hasn't seemed to be any problems with the 2 breeding dogs. The problem seems to be with the definition of the commercial kennel, and you know, therefore I'm in favor with the conditions that everyone else has put forth. So with that, I'll entertain a motion.
Hello, this is Elam Fisher speaking.
Mr. Fisher, we're on a previous case, so if you could just hold on the line, okay?
I was just wondering where we're at, or when shall I come in?
This is actually a case that we started at 10 o'clock, so it'll be a little while ago, okay?
Yeah, when shall I come back in? Will you give me a call? Or?
How about try back in, Mr. Fisher, in a half an hour?
All right, thank you. I'll see you.
Okay.
Bye.
May I make a suggestion? I know this is not typically how we do these things. In light of the board's, in light of where the board's discussion has gone, a commercial kennel allows up to 2, a commercial kennel is necessary if there are more than 2 litters per year. if there's not
Yes.
2 litters per year, this actually looks more like an accessory use. So would it, and I'm just trying to get this right. With the various restrictions you've considered, would it be better to table this for now, refer it to Mr. Voigt to determine the propriety of an accessory use of the location subject to those conditions? And that way, you know, you don't have to worry about the specter of a commercial use being approved, a commercial kennel being approved. It's just a thought.
I appreciate that.
Mr. Byers. But they testified that each dog would have a litter a year, so that would, so therefore that's the need for the commercial kennel license.
Well, the language of the code says breeding more than 2 litters per year, and if they're at 2, they're not over. They're not more than 2.
Mr. Bale.
Mr. Bowersox, a question of you. Why didn't you have that thought earlier?
I hadn't heard any of the testimony. And I was left with the application that my client received.
Mr. Chairman, can I say something?
Yes, Jay, go ahead.
It is true the way the code is written that a commercial kennel is if you have 2 dogs that do more than 2 litters a year. If you have 2 dogs and each dog's only doing 1 litter a year, that does not qualify as a commercial kennel. That would be an accessory use to the property. That being the case, if it's like I say, if that's all they're having, it's just the 2 litters, 1 from each dog, technically they wouldn't need the approval for the commercial kennel.
But Mr. Voigt, the grandparents have 2 dogs, they have 2 dogs. Once you get to 4 dogs on the property, you have to have the commercial kennel license, correct?
No, actually, no, they could apply for a private kennel, which is no more than 10 dogs on a property as pets. So if they're not doing a commercial business by having more than 2 litters a year, then they could get a private kennel and still comply with the law.
Okay. Do the judges have any comments about this?
Yes, I was just under the impression that comments and questions from anyone other than the board were over at this point in time. But I guess that's not the case. So when Mr. Bowersox decided to ask another question, I then have another comment, I guess. You guys are saying I can have potentially what you guys are saying, if you were to approve it, the stipulations would look like the commercial kennel license has to be null and void on this property when Mr. Jones and I stop living here, and we can only have 2 breeding dogs living at this residence, no more than 4 dogs living at the residence, correct? That's what's been said thus far. Well, if I'm allowed to have 2 breeding dogs, I could technically have up to 4 litters a year off of 2 dogs. At this time, I plan to have 1 litter, only have 1 dog old enough to breed. Next year, at this time, I will have 2 dogs who are old enough to breed, and 1 dog can be bred 2 times a year. So to go back to state what Mr. Voigt and Mr. Bowersox said isn't true. I couldn't have a private kennel. I would have to have a commercial kennel. And to be in good standing with the Humane Society and to be considered a breeder, and for them to not come in and say great length with the officer at the Humane Society, I would need a commercial kennel license. That is the reason why we put in the $800 and applied for all of this in the first place. Is we're trying to do everything the right way. And we came into the situation 100% aware that you guys could deny our request. But there are a lot of breeders in this county who you guys may or may not even know about that do everything backwards. The Humane Society has no idea about them. They don't do anything legally. And here, like someone else had stated a little bit ago, we're just trying to do the right thing. We very well could have done this and nobody would have even known because nobody sees any of the dogs except for our 2 Labradors that run in the backyard. So we could have done this and kept it on the quiet, but we are trying to do things the right way. We're trying to do things legally. We're trying to go through all the appropriate channels. And I guess that's all I have to say at this point. But I do believe that there is a difference between a need or use of a private kennel versus a commercial kennel. And although I feel as if commercial kennel is not really the category that falls under is what I need to be approved for, to be able to do what I need to do at this property with my dogs. So I don't know if, like I said, I was just a little bit confused on this conversation because I thought you guys were done with questions and comments from other people other than the board.
Okay, we've heard what Ms. Jones's comments are and Mr. Bowersock's. Board members, are we ready for a motion at this point or further discussion?
I'm ready to move on. And I move that in case 6287, we approve a private kennel for a limit of 2 breeding dogs with 1 litter each a year, to be raised inside.
And the associated variances and conditions as requested in the application?
Let me amend that, and that when they, if they move, that the kennel approval goes with them. Ends rather.
Okay, do I have a second?
I'll second it.
Okay, is there discussion on the motion?
Is the motion to approve a commercial kennel or a private kennel?
Commercial.
Well, okay. I think the screenshot that Mr. Bowersock showed would probably make it a private kennel because of the number of litters a year.
Unless I misunderstood, I'm sorry.
Go ahead, Ms. Eckert.
Mr. Bale, I feel like the Joneses needed the specific classification as a commercial kennel to be able to be breeders or recognized by the Humane Society, and I guess the AKC is AKC, for what they're doing.
That's my understanding, and if they actually had more than 1 litter out of each one of the dogs per year, that would require that they have a commercial kennel license.
Well, correct me if I'm wrong, but in Gary's motion, he said private kennel, not commercial kennel.
That's what I heard.
I'm amenable to changing it.
I think in order for the Joneses to comply with the Humane Society and the American Kennel Club, they have to have a commercial kennel license. So would you be amicable to that?
Absolutely.
Okay.
Absolutely.
Ms. Eckert, you seconded the motion, Ms. Eckert. Are you amicable to that?
Yes.
Okay, so we have a motion to give conditional use for a commercial kennel and the distance variances. Is everybody good on that? Any further discussion? All those in favor say aye or raise the right hand.
Aye.
All opposed, no. My visual is down right now. Mr. Wirtz, how did you vote on that?
My vote is no.
Okay, So the motion carries. So the approval is given with those conditions in the motion. Our oral decision will become final upon a written decision, which will be issued within 30 days unless otherwise extended by this board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. This hearing is over, and we're going to take about a 3 or 4 minute break. I have to reboot everything. I don't have visual right now, so I'm sorry about that. So let's take about a 3 or 4 minute break, and we will go to our next case.
Thank you.
Thank you.
to an application for a conditional use for a country inn will now come to order. Mr. Dixon, would you please introduce the files?
All right, case 6292, an application for conditional use for a country inn. The site is located at 125 Kate Wagner Road, Westminster, Maryland, on property zone A, agricultural district in election district 7 by Karen E. Stewart, Code of Public Local Laws and Ordinances, section 158.070 E1T and 158.071 D7. A site visit is tentatively scheduled for Wednesday, January 20th, 2021 at approximately 9:15 a.m. Just for the record, there was a postponement request by Clark Schaefer in this matter, and the postponement request was denied. And then there was I guess a motion for reconsideration by Mr. Schaefer, and that motion for reconsideration of the postponement request, that was denied. All right, in the file of this matter, we have the following documents. There's the site minutes. There is a January 23rd, 2019 letter from Mr. Schaefer, or from Melvin Bell to Mr. Schaefer that the board denied his request for reconsideration. There's a January 14th, 2021 letter from Clark Schaefer to the board requesting a postponement. On behalf of his client, Kim Unseld. There is a January 15th, 2021 letter from Linda D. Eisenberg, Secretary to the Planning Commission, to the board. After having reviewed the information contained in the attached analysis, the facts as presented in the application, the relevant portions of the plan, and in accordance with the provisions set forth in the land use article, this conditional use request, if granted, is consistent with the policies, timing of the implementation of the plan, timing of development, timing of rezoning, development patterns, land uses, and densities or intensities. There's a January 12th, 2021 memo from Hannah Weber, planning technician, to the board. The above referenced BZA case has been reviewed for consistency with the policies and recommendations contained in the 2014 Carroll County Master Plan as amended in 2019, the Carroll County Water and Sewer Master Plan, and other functional plans. The staff finding is that this request is consistent with the 2014 Carroll County Master Plan as amended in 2019 and would not have an adverse effect on the current use of the property. There's a response to Joe Vance's request to various state and local agencies from Laura Mateus, Bureau Chief, Development Review. Comments: a site plan will be required in accordance with Chapter 155. There's a response to Joe Vance's request to various state and local agencies from Tom Harris, Permits and Inspections. The event's tent shall be considered as seasonal use with a 6-month limitation per year. If portable restroom facilities are to be used with the health department's approval, the number of events would be limited to 12 per year. Accessible parking and routes will be addressed during the site plan process. A building permit shall be obtained for each yearly seasonal use. There's a January 12th, 2021 letter from Clark Schaefer. He needs time to conduct inquiries, investigations, and studies that may be appropriate to evaluate and potentially contest the matter. Hearing notice was posted December 28th, 2020 by Scott Robinson, zoning inspector. There is a response to Joe Vance's request from Matt Shipley, Carroll County Environmental Health Department. Proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply and adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses on this property. There is a January 6, 2021 email from, looks like Barbara McMahon, to Mr. Voigt. She lives at 32 Kate Wagner Court. She had a concern about music that would take place at events on a regular basis, and that noise. She enjoys the peace and quiet of sitting on her deck and listening to birds and talking with friends. There's a January 4, 2021 notice of public hearing for this case. There's a response to Joe Vance's request from Deborah Bowers, Program Manager, Ag Land Preservation Program. Comments not in agricultural land preservation per DB Deborah Bowers. There is a January 4th, 2021 email to Jay Voigt from Amy Barcroft. She won't be able to attend this hearing. She lives across the street on Kate Wagner Court. She has a concern about the music within a reasonable volume. She's not trying to stop this from happening, but as the property is my largest investment, she wants to protect it for the future and our quality of living. There is a response to Joe Vance's request to various state and local agencies from Christopher P. Hahn, Bureau Chief Resource Management. No comment. There is a response to Joe Vance's request from various state and local agencies. Jay Voigt, Zoning Administrator. We'll need a site plan approved by the Planning and Zoning Commission. There's a notice of public hearing for this case dated December 22nd, 2020. And then there's an application for conditional use for Country Inn. There are plans in the file from BPR Inc. for this place. There was a complaint about 2 illegal businesses being run from the property that the zoning administration did an investigation on. And then there's some photos of the property. I would ask that the file be entered into evidence.
Could I get a motion?
So moved.
Second?
Second.
All in favor, say aye or raise your right hand. All right, the motion carries. The file will be introduced into evidence. I believe Mr. Bale is back with us. Perhaps maybe caller 7. Mr. Bale, can you hear me?
I'm on the phone, but I have no visual, so it's a little hard for me to run the meeting. So could you run the meeting and I'll be here.
Okay, thank you. Mr. Schaefer, prior to opening the meeting, brought up the fact that he had asked for a postponement. And Mr. Bale, it was my understanding that you were going to perhaps address this at the hearing, this hearing?
Yes, it was my response to Mr. Schaefer was based in part on legal advice that we, as a board, got, and also a conversation that I had with each member individually before I sent that letter. So I don't know if that answers Mr. Schaefer's question or not.
It answers, it gives me some more information because, but it does not answer the question. I just want to make a formal on the record objection to the denial of the postponement request and to clarify the record so that it's clear, because all I have before me is that I filed two requests in writing. I have no written response other than a two-line letter from the board saying no. So if I may, and I'll be brief here, I think, the zoning inspector, not due to a complaint by the Unsells, my client, visited that property on October 15th, 2020, and informed the applicants that they needed to file zoning applications. They signed this zoning application on or about November 30th, 2020, and probably filed it around that time. My clients did not get any notice of this until over the Christmas holiday season, between Christmas and New Year, when they received a letter. They immediately called me. I then called the BZA offices because all they got was a 4 or 5 line description, country in, no other information. And they had no prior notice that this application was going to be made, despite having been neighbors out there for 20 years or so, 30 years. In any event, I then tried to go look at the file at the BZA offices, but the BZA offices were closed over the holidays. I went over on the Monday, the first day in January 4th, to look at the file. And at that point, I got copies of the file and proceeded to talk to the Unsells and start to prepare the matter. I'm not going to go into detail. We were unable, in our opinion, to meaningfully investigate what was going on and prepare for the matter. I then filed the first request for postponement in writing and in accordance with section 158.133F of your code, which says that if you file less than 10 days, if you request a postponement less than 10 days from the hearing, you're required to support it by affidavit and show good cause. It then says if you file more than 10 days prior, it's in the discretion of the board. Now, may make no difference to you, but in my experience over 40 years, and by the way, I don't think that particular section has only probably been in the code for about 15 years, 20 years. First requests for postponements made more than 10 days are almost routinely granted. Not in the code, okay, it's in the discretion of the chair. The chair, in this case, went out of his way, and I applaud him for it, to check with the board because I guess he could see it was an important decision or whatever. But the bottom line is that it is, I submit to you, that it is very clear, and I don't know, at this point, I have no idea what reasons are out there, if any, that this postponement is bad or hurts anybody. Because I've never gotten a written response from the opponents, and I've never, so I submit to you that it is not fair to deny this postponement, that it does in fact prejudice the Unsells preparation and investigation. I proffer to you that I called 2 traffic experts, both of whom over a week or 2 period told me we don't do opposition work, meaning they don't testify in support of people that are opposing applications. Now, whether we would get a traffic expert, probably not at this point, even if we had 30 more days. You never know. But it is prejudicial to the applicant, I think you can see that from your everyday life. If you got a notice in the mail that your neighbor was proposing a major use, and it was a 3-line notice, and you were then put on a time period where it was about 22 days, 22 calendar days, to investigate, see if you maybe would get land use consultant, maybe talk to an appraiser, maybe figure out, maybe talk to your neighbors, which we'll get into that later. So I respectfully request that you revisit, that you consider the request for postponement and grant the postponement today. I think it would allow us to investigate the matter. I know it would. It's possible, although not guaranteed, that it would allow for a some sort of neighborhood peace accord. Any exigency on behalf of the applicants here seems to me is ameliorated by the fact that they've had plenty of time to deal with this. And if they have an exigency, it's of their own making. For instance, if they've got, I understand from the zoning investigation file, they've scheduled a wedding for May. They got one scheduled for May. I don't know if that's one of the reasons, because there are no reasons, but I know that from the zoning investigator's file. That's not my problem. That's that thing on your desk that says your failure to plan does not constitute my emergency. So I respectfully request that you revisit the decision, grant the postponement, give us the 30 days or however long it is, and let's see what we can do. And I appreciate the opportunity to make my statement at the beginning of the case. Thank you.
Mr. Lazuriaga.
Thank you, Ms. Eckert. Good 10 minutes afternoon, board members. My name is Matt Lazuriaga, and I'm representing the applicant in this case in Karen Stewart and Good Feelings Farm, LLC. I'll respond just briefly in pointing out that Mr. Schaefer correctly pointed out that all decisions regarding postponements of BZA cases are within the discretion of the chair of the BZA, at least as it relates to subsection F2 in requests made more than 10 days prior to the hearing. And then within 10 days, it's in the discretion of the entire BZA. Based upon what the chairman has indicated, it sounds like the entire board had the opportunity to weigh in the first time this has been requested. I don't know if they've had the opportunity to be consulted as to the second time, but as far as what's the hurry, in this instance, I'd respectfully represent to the board, the applicants in this case are in a favored status. This is a conditional use that is presumed to be appropriate for their property, so long as they check a number of items on the list that are the conditions associated with the use. They can do that today. They're prepared to do that today. Obviously, the applicant's going through the exercise of hiring me. She's paying for my time and my services. Mr. Bechtel is there with me. She's paid for his services. He's here today. And we're prepared to create a record that I think is going to not only be successful before the board, hopefully, but it's going to be solid enough that even if there were speculative evidence to the contrary, I think it would be a successful application. Now, to be complete on the thought of the postponement itself, and I encourage the board to consult with its legal counsel on this to the extent it already has not. A discretionary call is one that is not going to be disturbed unless it is an abuse of your discretion. And the only thing really been proffered to suggest that a postponement ought to be granted is that the Unsells have found themselves in a position like anybody else in a zoning case where they received the notice of what's going on and they weren't able to secure the type of evidence or supporting testimony that they wanted to prior to the hearing. I'm not unsympathetic to that. I've had clients where that situation happens all the time, but just because their efforts to obtain a traffic expert or someone else were not unsuccessful because somebody wasn't available, but because the people that were consulted just don't do that work. I don't think that that constitutes a good basis for continuance, and I request that the board hold its decision made once or twice to not continue today's case.
May I please ask a question?
Pardon me?
I'm sorry, may I ask a question, please?
Yes.
Thank you. Excuse me, we're Doug and Wendy Rook. Our property directly adjoins the property in question. We are roughly to the southeast of them.
Excuse me. I'm sorry, excuse me. Is this in relationship to the request on the table for a postponement?
It may be, yes.
Okay.
Sorry, I should have clarified. My concern is that our property directly adjoins the Stewarts, and we received no notice at all from anyone about any kind of a hearing or a request for variance. There has been hearsay among neighbors that this was coming. And we got a text last night from a concerned neighbor saying, hey, there's a meeting tomorrow. You might want to take a look. I don't know if that would have any bearing at all on a postponement or a continuance, but we've had no time at all. And our property adjoins the one in question, as does the Unselds.
Thank you.
Madam Chair, that I was going to bring this up as my second preliminary, but now that Mr. and Mrs. Rucha brought it up, I looked at the list of adjoiners, and without going through them sedulously, it was very clear to me that there were no notices provided to anybody across Kate Wagner Road from this property. Now, interestingly, your zoning ordinance refers to contiguous property owners, with which Mr. and Mrs. Root have just indicated they are. But page 5 of your zoning application itself, and the one that was filled out by Miss Stewart, where she was required to list those property owners, says, and any owners of property situated on the opposite side of any street or road from the property involved in this application, in order that notification of the public hearing can be forwarded. That was not done in this case. And across the street are several properties, including the edge of Diamond Hills, which is a 400 unit subdivision. So I believe that that is a due process procedural defect, which frankly would be better and could be corrected in the event of a postponement by providing proper notice to people in accordance with your policies and procedures on the application form itself. Thank you.
Thank you. Mr. Luzuriaga, do you have anything to add to that statement?
I do. Thank you, Ms. Eckert. As Mr. Schaefer pointed out, the adjoining property owners the certification was filled out by my client prior to my involvement. That's a pretty big issue for due process for anybody in the neighborhood. So I venture to say, if we were successful today, that would probably be grounds for somebody to appeal. So I will leave it at that.
Thank you for your candor. Mr. Bale?
Chairman, this is Randy from BPR.
Yes.
I apologize to the Ruches. did not pick up how to pronounce their name. But they are not a direct adjoining property owner. Their property is separated from the Stewart property by the unsold property.
Yeah, that is accurate. The driveway does go through, yes. Between.
Ms. Eckert, if all the neighboring properties were not properly notified, I would suggest we ought to consider a postponement.
I would agree with you, Dr. Dunkelberger. I will entertain a motion.
I make
I
a
would-
motion that we first. Gary, you want to make a motion, Gary?
No, you go ahead. I'll second it. If I like it.
I think you will. I'm looking for the case number and I can't find it right this second. What is the case number?
6292.
In case number 6292, I make a motion that we postpone the hearing until all proper notifications are carried out.
Second.
All in favor, say aye or raise your right hand, please.
Aye.
Aye. All opposed? Mr. Bell? Mr. Bell?
Aye. Didn't you see me raise my hand?
No, my apologies. Okay, then. The motion carries then. Five.
May I make an inquiry? Ms. Eckert, you're muted.
My apologies. Okay, so the hearing and record of this case is now closed. My apologies. I've never had a postponement. I'm not sure what comes next.
Joe,
May I-
when's the next date going to be for this hearing?
What did you say, Tim?
I asked Joe Vance when the next date would be for this hearing.
Probably the end of February.
February 23rd.
By the way, if I may, this is probably more correctly described as a continuance since the hearing has been called. And that serves the purpose of at least letting everybody on the call know what's going on without providing them explicit notice in the future. Just a point, I think it's a point. This is a continuance. And now, Mr. Dixon, yes, let's find out when the continuance is to, so that we can state it on the record, so everybody that's on the record knows when it is. Thank you very much.
All right, Joe Vance said the next date's going to be February 23rd, so you'll find out in the notice the time, but that'll be the date of the next hearing.
If I may inquire, at first I agree with Mr. Schaefer about it being not a continuance by way of nature. On the 23rd, I'm not going to let this other matter I have stand in the way. So if I'm told no, that's fine. I have another administrative matter that day at 10 o'clock. Is it possible to be scheduled in the afternoon, or is that entirely dependent on the remainder of the schedule?
Joe?
I can do that. You guys would might have a gap. The other option would be just to hear two cases on the 23rd and hear Mr. Luzuriaga's case on the 24th, whichever would be preferable.
Mr. Luzuriaga do the 24th?
Yes, Mr. Simmons, I can.
And as can I.
Other board members?
That should be fine.
It's fine with me.
Gary?
Gary has stepped away for some reason.
Chairman Ecker, excuse me, Randy with BPR, and here with the applicant. We're both available on the 23rd. 24th.
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 Melvin, are you?
I'm good.
You need a motion?
Do we need a motion to do this? Mr. Dixon, do we need a motion?
I'm sorry, I didn't hear you.
Do we need a motion to reschedule or to schedule the continuance on February the 24th? Or are we good just to?
No, we just announced it. You're already granted the continuous, so all we need to do is give them a date. So it's gonna be the 24th. Do we know the time, or just know the 24th?
Joe, is that gonna be 9?
Yes.
Okay, February 24th at 9 a.m. We will continue this case. All right.
Thank you very much.
Hearing is adjourned. Thank you, everybody.
he'll introduce the file.
Thank you.
All right, case 6294, an application for a conditional use for a commercial kennel for up to 20 dogs. The site is located at 1800 Broadbeck Road, Hampstead, Maryland, on property zone A, agricultural district and election district 8. By Elam S. Fisher, Code of Public Local Laws and Ordinances, section 158.070E1I and 158.040. A site visit is tentatively scheduled for Wednesday, January 20th, 2021 at approximately 9:50 a.m. In the file of this matter, we have the following documents. Site minutes for this case. There is a response to Joe Vance's request to various state and local agencies from Hannah Weber, Comprehensive Planner, Bureau of Planning. It's a January 12th, 2021 memo. States the above referenced BZA case has been reviewed for consistency with the policies and recommendations contained in the 2014 Carroll County Master Plan as amended in 2019, the Carroll County Water and Sewer Master Plan and other functional plans. The staff finding is that this request is consistent with the 2014 Carroll County Master Plan as amended in 2019 and would not have an adverse effect on the current use of the property. There is a January 15th, 2021 letter from Linda D. Eisenberg, Secretary to the Planning Commission. After having reviewed the information contained in the attached analysis, the facts as presented in the application, the relevant portions of the plan, and in accordance with the provisions set forth in the land use article, this conditional use request, if granted, is consistent with the policies, timing of the implementation of the plan, timing of development, timing of rezoning, development patterns, land uses, and densities or intensities. There's a response to Joe Vance's request of various state and local agencies from Laura Mateus, Bureau Chief, Development Review. A site plan will be required in accordance with Chapter 155. There's a response to Joe Vance's request from Tom Harris, permits and inspections. A building permit is required for the kennel structure. The areas for the viewing and interacting with the dog shall be ADA accessible. There's a response to Joe Vance's request from Matt Shipley, Carroll County Environmental Health Department. Proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply and adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses of this property. Hearing notice was posted December 28, 2020 by Scott Robinson, zoning inspector. There is a newspaper advertisement dated January 4th, 2021 for this case. There's a response to Joe Vance's request from Deborah Bowers, Program Manager, Ag Land Preservation Program. This property is restricted by a state mouth conservation easement that does not allow dog kennels, as they are a non-agricultural commercial use. This requested use, therefore, cannot be allowed. That's from Deborah Bowers, Program Manager, Ag Land Preservation Program. There is a response to Joe Vance's request from Dawn Kenna, Humane Society Animal Control Officer Dispatch. Comments? No comments. There's a response to Joe Vance's request from Christopher P. Hahn, Bureau Chief, Resource Management. Plot plan does not include dimensions of proposed structure. There's a response to Joe Vance's request from Jay Voigt, Zoning Administrator. No comments. Joe Vance sent a December 22nd, 2020 notice of public hearing to the applicant, adjoining property owners and interested parties. Then there's the conditional use for commercial kennel for up to 20 dogs. Application includes aerial photographs, handwritten notes to the plot plan, see an investigation by the zoning administration. I would ask the file be entered into evidence.
Do I have a motion to enter the file into evidence?
So moved.
Second?
Second.
All in favor, raise your right hand or say aye.
Aye.
Okay. We will go ahead and move the file into evidence.
I would just counsel the board that as a preliminary matter, we should probably deal with with that note from Deborah Bowers. That it can't be allowed because it's restricted by a state conservation easement, MALP, M-A-L-P-F, easement that does not allow dog kennels.
Mr. Dixon, do you know what that is? And can you fill us in on it?
All I know is there's some sort of restriction due to this MALP, but Mr. Voigt looks like he wants to speak to it.
I do have some further information on Ms. Bowers' note. Upon further research, yes, there is a MALP easement that's on the property. However, with that easement, there is a 1 acre spot that surrounds the existing curtilage area on the property that is not in the easement. And I discussed that with her, and it was determined, since that 1 acre is not in the easement, if the kennel is located within that 1 acre, then yes, he can do it. It can be done. As long as the location of that kennel is within that 1 acre spot.
And Mr. Voigt, my question is that delineated or is that a
It's
1
delineated.
acre?
I'm sorry.
So it is specifically delineated. It's not just an acre on the property that's excluded from the easement.
It's surrounding the house, in the curtilage area around the house. So if it's within that acre around the house, and it's also described in the agreement where the location is, but it has to be within that acre, and then he can do the kennel.
So your testimony, not your testimony, but your guidance here before we even get started is that we can go forward with the hearing because what Ms. Bowers put there was in the file was not technically correct. So we can go forward with the case. That's what you're saying.
Well, yes, correctly, she was correct that you can't do it within the easement area, but like I say, anything outside of that easement area, you can do. Deb has just shown up, so I think she could explain it perhaps a little better.
Okay, Ms. Bowers, are you on?
Deb, you got to turn your mic on.
Ah, there we are. Sorry. So
Okay.
you're talking about the Fisher property, Melvin?
Yes. Yes.
Okay. On Broadbeck Road.
Yes.
So that's a mouth easement, and when he requested a kennel, we consulted with mouth, and they said no, that's not going to work. And then later on, we found out that he had a 1 acre exclusion from the easement, Melvin. So he can do what he wants within that 1 acre, and he knows where it is on the property.
And can you describe for us, Ms. Bowers, where that 1 acre is in relation to the buildings?
Yes, it's directly north. It's been a while since I looked at the file, and I don't have it in front of me right now, but it is directly north. And And as I understand it, it is uphill from the home.
So that location would, and this question actually goes to Jay. If that's the location, it's next to a property line and it would need some variances?
It is on the property line.
So we just dealt with this in the ag zone. The setback is supposed to be 200 feet. So if we granted this, there would have to be some variances that that we would have to rescind the 200-foot setbacks. Is that correct?
Mr. Bale?
Yes.
If the property is larger than 3 acres next to that property line, then it has to be the 200 feet is from the residence of the adjoining property, not from the property line.
So therefore, probably being where it is, since our site visit, there wouldn't need to be any variances there. Just the conditional use of the commercial kennel.
Correct.
Okay. Board members, any questions of Mr. Voigt or Ms. Bowers before we start the case? Okay, very good. Mr. Fisher, I'm assuming you're still on the line. What we're going to do is you'll go ahead and present your case for your application, and then we'll have the opportunity to question you, and then any interested parties can go ahead and give their testimony. But before we get started, Mr. Fisher, could you please raise your right hand and take the oath? Do you swear under penalties of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I affirm.
Very good. Okay.
Thank you.
Mr. Fisher, the call is yours. So can you go ahead and describe what your conditional use is for here today?
Sure. Good. Yeah. Thank you for letting me in here and your cooperation here. And I was here to listen what you had in mind. Everything made sense to me, what Deborah Bowers said and your concerns on that part. So yeah, I'm basically just requesting a commercial kennel, I guess it is down here. We're moving down from Pennsylvania, Lancaster County. So I'm new in the area. I wasn't sure what direction we need to take down here. But yeah, I made a request. I did get some feedback back. I didn't realize that we are on a easement here that doesn't allow kennels. And then we got to the point that there is an acre here on the property that is aside from the easement. And I thought that would be possible to put the kennel on that 1 acre. It's not far from the buildings, directly north from the buildings. So basically, what I'm doing here, I did request up to 20 dogs, just in case I ever want to move up a little bit. But at this point, we have right around 8 females, few males. We do raise dogs and try and sell them for pets. We do some wholesale, some retail. I guess I was looking at, either way, that I could have choice in whichever way I want to sell them. So I don't really know what more to say, but just, yeah, that's a family thing that we've been doing here for 18 years from where we are. The children enjoy the dogs, and I like to interact with families and sell healthy puppies to happy parents and children. So that's kind of where we're at. If you have any comments or questions, I'm here to answer whatever I can.
Okay, does anybody have any questions of Mr. Fisher?
would you be constructing any buildings?
Yes, we would actually be constructing a prefab building.
What would be the size of it?
It would come every. I would be looking at a 38 by 12, and then exterior runs. And I didn't mention I would be putting a privacy fence completely around the kennel to eliminate noise from the dogs barking and so forth. So it would be a heated interior, and then they would have access to go outside on runs as well.
Okay, any other questions of Mr. Fisher? Anyone from the public have any questions of Mr. Fisher? Okay, are we finished with the questions, guys? I didn't see anybody's microphone light up. Okay, presentation and testimony of evidence is now closed and summations are in order. Mr. Fisher, do you have any summation comments? Any closing comments?
I don't think so. One question is, would I have to do a survey to make sure that I know exactly where that property is? Where that 1 acre is? I have a map, a deed that I can get footage. I think I could, very close, but
I would say that when you get the building permit, you're probably going to have to locate it. So it would have to be located there. But that's speculation on my point.
Yes. Thank you.
Okay. Any other summation comments, Mr. Fisher?
I don't have anything in mind.
Okay.
Thank you.
Very good. The hearing and record of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. So board members, who wants to go first?
I'll go first. This seems like a clear, concise approval, depending upon our approval. Having visited the site, it looks ideal for what this gentleman wants to do. And there didn't appear to me to be any contiguous neighbors who are going to be impacted, and there's obviously nobody testifying in opposition. So I think this is an easily approvable request.
Okay. Mr. Wirtz?
I'm in favor of granting the request, provided the motion clearly indicates that the kennel has to be located outside the preservation easement.
Okay, Ms. Eckert?
I agree with both Mr. Wirtz and Mr. Simmons. I'm ready to vote in favor of this.
Dr. Dunkelberger, any comments?
I don't think we have enough information to know exactly what this would look like. I find it hard to vote for or against it, and I will abstain.
Okay, any further comments?
I'd like to respond to Dr. Dunkelberger. We're asked about the land use, not what it's going to look like.
That's a good point, Dick.
We don't often.
Okay, any further comments, guys? Okay, I'm ready for a motion.
I'll make a motion. In case number 6294, I move that the board approve a conditional use for commercial kennel for up to 20 dogs, provided the kennel is located outside the ag preservation easement, otherwise known as a mouth easement.
Do I have a second?
I'll second. We got two
Okay,
seconds.
we have a motion and a second to approve a commercial kennel for up to 20 dogs outside of the mouth easement. Any further discussion? Seeing none, all those in favor say aye or raise your hand.
Aye.
I'm persuaded by Dick.
Okay, it looks like a unanimous decision. Our oral decision will become final upon a written decision, which will be issued within 30 days unless otherwise extended by this board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County, in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much, and this hearing is over. Thank you, Mr. Fisher.
Could you say that again? What, I guess I'm new in this, what did you actually come up with?
We approved your commercial kennel for up to 20 dogs in that 1 acre exclusion. It can't be in the ag preservation easement.
Right. Do I get a written notice of that, something that I have to keep and show that this has been approved by the county? Or do I?
You will get a written decision of our motion here today.
Good.
Okay.
Okay. Yeah, that was my question.
If you do have any question, you can call Ms. Vance. Okay, and or Mr. Hoyt.
I greatly appreciate your time, and yeah, thanks for your help here.
Very good. Thank you.
Okay. You're quite welcome.
Okay, board, do we need a break or should we go right to our 11:45 case?
I'm ready to go.
Very good. Okay. We have case number 6275, which is a continuation of the case from the previous month. Ms. Huff, are you on?
Yes, I'm here.
Okay, very, very good. Okay, with that, with this, we'll go ahead and can you or anyone else that may be on the line, could you raise your right hand and take the oath, please?
Okay.
Do you swear or affirm under the penalties of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Very good. Okay, with that, Ms. Huff, I'm just going to go ahead and open it up. Please state your name and address and occupation and spell for the record your last name, and go ahead and tell us what has transpired since the last BZA hearing.
Okay. Amanda Huff, Huff, and I'm at 1416 Fairmount Road in Hampstead, Maryland. The case is regarding a family daycare in my home. Since the last meeting, I had someone come out and assess my property lines. We discussed putting in a turnaround area just off the edge of my driveway that would extend into the front of my yard. I think the issue that we had was making sure I wasn't encroaching on county property. So there should be 2 copies, the original, and then one where I drew and showed the size of, I'm sorry, it's so tiny because I'm on my phone, but I think that's it. So it will show where the turnaround area would be. So they would basically be doing a K-turn so that they could then back into the driveway to not cause any backup on my road.
Did everybody have the opportunity to see that?
I saw it on our site visit.
Okay, does anybody have any questions about Ms. Huff's drawing? And what, Mr. Voigt, I see you put your hand up.
Yes, like I say, there was concerned about pulling into the property. And Mr. Devilvis, our director, is the one who made the original decision on this case, but he couldn't be here today. So he asked me to cover for him and take care of this. Neither he nor I have problems with the proposed turnaround. The only thing that we would ask is that the turnaround go at least to the far side of the house so that there's enough room for basically a 20-foot parking space off of the driveway so somebody can pull around, turn into it, and have clearance. Other than that, after we discussed it this morning, neither one of us has any other issues except just making it a little longer than what's shown on the plat. That was it.
Okay, Ms. Huff, you heard what Mr. Voigt's recommendation is. Do you have any issues with complying with that, making it, and are you saying, Jay, 20 foot is what you're recommending?
Yes, basically from the edge of the driveway, that the turnaround be 20 feet long, which is what the standard parking space is for any car, so that there's room to make a safe T-turn to pull it back out of the property.
I don't have any problems with that at all.
Okay, board members, any questions of Mr. Voigt or Ms. Huff?
Well, Jay, how should this be handled? If it's approved, should there be a contingency that a suitable plat drawing be provided to you for your approval?
Yeah, we'll make sure that the driveway is suitable and everything can do. Make sure it complies with what the plat says. Like I say, goes at least as far as the other side of the house.
Does that answer your questions, Dennis?
Well, sort of. I can't really see the plat. The plat wasn't really legible to me. So I can't really see exactly what is proposed. That's my...
Well, just one other thing, Mr. Wirtz, just to let you know that a zoning certificate will need to be issued for this property for the family daycare. And like I say, prior to that certificate being issued, we will ensure that the driveway turnaround that they're putting in is going to be adequate for the proposed use.
So there are checks and balances there.
Yes.
Okay. So does that answer your question, Mr. Wirtz?
Yes.
Okay, other board members, do we have any questions?
Not I.
Okay, and I'm assuming there's no one from the public on the call. Is that correct? Okay. Presentation of testimony and evidence is now closed and summations are in order. Do you have any concluding comments, Ms. Huff?
Thank you. The only thing that I have is I have one of the grandparents of the children that was at the previous daycare that I had is a general contractor and offered to do the work for me. Do I need to have him draw something up, or do I need to take pictures once the work is done? How do I conclude with my end of showing that I'm doing things the correct way?
If you could have the contractor draw something up showing exactly what he's doing, and then once he's done the work, give us a call and we'll come out and verify everything. And if everything is proper and correct, we'll go ahead and at that time and issue the zoning certificate.
Thank you very much.
Is that everything, Ms. Huff?
Yes, thank you.
Okay, very good. The hearing and record of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. Board members.
I think that Ms. Huff did what we asked her to do and provided a good solution, or at least a workable solution to accommodate the parking and the turning around on the site, and I am prepared to vote in.
Okay, Dr. Dunkelberger.
I agree with Lisa. I think she's absolutely right.
Mr. Wertz.
I mean, I'll go along with, I respect Jay and Tom Devilvis's opinion. I'm satisfied with it.
Mr. Simmons.
I agree with everything that's been stated.
Okay. We will go ahead and I'll go ahead and introduce. I will go ahead and allow you to make a motion at this point. Do we have somebody to make a motion?
In case number 6275, I move that we overturn the zoning administrator's denial of a home daycare facility in case number ZA1936.
Do I have a second?
No, wait, wait, before you do, this is de novo, right? Tim?
Mr. Dixon, is this a de novo case, or how should we be approaching this? Is this an appeal?
Yes, I think it's a de novo case. But you can still state it the same way you were. We're overturning the denial, or you could just say the board is approving what the daycare. The board's approving the daycare.
Okay, so her motion is technically correct. Do we have a second?
I'll second that.
Okay, we've got a motion and a second. Any further discussion on the motion? Seeing none, either raise your hand or say aye.
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 It was an either or there, Gary. It wasn't both.
I wanted to vote twice.
Looks like the motion carries. It's a unanimous decision. Our oral decision will become final upon a written decision, which will be issued within 30 days unless otherwise extended by this board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much, guys. And actually, we're only an hour behind time, so we didn't do bad. Thank you very much.